The following program is recorded with a 5-second delay. In the event of something truly horrific happening, the host has 5 seconds to calmly interrupt the flow of the stream and prevent the content from reaching your sensitive eyes and ears. Alas, the host has absolutely no clue whatsoever which buttons need pressing to abruptly halt a stream, so he will likely spend those precious moments screaming, "Oh my God, no, how could this have happened? Holy hell, oh my God, no, 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 why didn't I figure out how to fix? I knew this would happen, oh my God, I suck, damn it, damn it, damn it." Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, a.k.a. Good Lawgic. Host, I say. I have some good, interesting developments. Some developments that I'd like to share with you all. I got to tease that out for a moment or two. Maybe more than a moment or two. I'm not going to kid you. Share with you what has been going on in the world of Trump trying to get ungagged. The world of Trump trying to get ungagged. Well, the world learned today that Trump's efforts to get himself ungagged were unavailing before the First Department. A lot of people forwarded that to me as soon as that hit the news, wanting to see what my take would be on it. I almost did a locals breaking it down. And I would have done it locals. This is not like, it's not something I was like, oh, maybe I'll do it. No, I just didn't have the time. And the reason I did not have the time is because I got a new application and I was working on that. Now you might say to me, Joe, why are you working on this? Don't you have a lawyer now named Ron Baruti, who seems really based, really smart, really good what he does? He's a fairly good writer even. He's pretty good. He's solid, rock solid. Why would you? It's because I was like, I want to change this part. I want to change that. And I basically spent the better half of 2.5 to 3 hours editing papers. So I will get to those papers and what our objective and agenda is there and why this is such a critical development to try and get relief here and get this case ungagged. So the first what I want to do is I'd like to break down for you the decision that was issued by the First Department today, where they were rejecting Trump's application to get the gag order removed himself. And you're going to see how different his application is from mine. And I wish I could phrase this. I'm going to be respectful to everyone involved here. I'm going to be respectful. I'm just going to say that he and his team, and perhaps his team was guided by him. I don't know, but that would somebody made the decision on the direction to take here, which is very different from the direction I chose to take. I'll walk you through that. In fact, let's get into that right now. Let's do it. Let's look at what, and I need to clarify for you that we don't know what Trump's arguments really were completely, because the whole thing is sealed. It's sealed. No one can access his case, which I don't know why it was sealed. I'm not questioning the jurisprudence of that decision. I'm simply recognizing the fact, which is it was sealed. And yes, for the love of God, everyone smash the like button. In fact, I need to put this up here now. To support. I should do this before the stream starts. Support my efforts to ungag Trump Please visit. No, just do it this way. Please visit. Please visit. I'm just going to type that out. Give you a nice clickable link. / Trump. Does that look right? It looks right. Okay. I do need to. Oh my, I didn't share this out. I'm so stupid. That was so bad. I didn't share this out. I thought I never had send. All right, well, hopefully people get that. And I didn't do it on X either. I've been so busy. Busy Joe. All play and no work makes. All work and no play makes Joe a dull boy. All right. Well, there you go. That's that. Smash the like button. Oh, and I should go over here and actually pin that because otherwise, where was you? Pinned. All right, let's get to work. Let's get to work, my friends. We got work to do. Supreme Court State New York Appellate Division. All these constitutional scholars who weighed in here. All these constitutional scholars who weighed in. I'm going to tell you right now, if Lawrence Tribe is one of the constitutional scholars, which apparently he is, these constitutional scholars were not weighing in and recognizing the Constitution. Just saying. Just saying. Ethical experts and former public officials. This is just a consortium of clowns with way too much prestige. Way too much prestige. Scroll down. No scrolling. All right. Petition to pursuant to CPR 7803, challenging order of the Supreme Court, New York County, Juan Marchand, entered March 26, 2024. The original restraining order and amended on about April 1, 2024. The amended restraining order. I still like my abbreviation of ORS and CORS way better. Way better, but that's just me. Just saying. Oh, whoops. In this Article 78 proceeding, let's just get into it. Petitioner asserts one cause of action for judgment pursuant to CPLR 780302. This section is a codification of common law writ of prohibition, which is available to restrain an unwarranted assumption of jurisdiction to prevent the court from exceeding its powers. Matter of Trump v. Engeron. There we go. Okay. The Court of Appeals has found that the extraordinary remedy of a writ of prohibition lies only where a clear legal right to such relief exists. When a court acts or threatens to act with either without jurisdiction or in excess of its authorized powers in a proceeding over which it has jurisdiction, even in the rare circumstances where Article 78 review will lie with respect to a writ of prohibition, it does not issue as of right, but only as the sound discretion of the court. Okay. All right. I wonder if they're going to try and use that against me. I don't think so. Because I think normally I think what they're basically saying is normally you have to appeal. In other words, Donald Trump, in certain ways, ironically, is in a weaker position jurisdictionally. And this I'm speculating about. I'm not saying I'm theorizing. I'm not saying this. I'm not giving you legal education here. I'm giving you speculation. And that is the normal way for you to deal with an order you don't like is you appeal the order. It would not be an interlocutory appeal. So now he wants to circumvent the normal appeals process and apply for this relief via Article 78. Accordingly, I can understand how he doesn't have necessarily a right, but he has to get permission to do that from the court, as indicated here in this order. The sound discretion of the court, as opposed to an issue as of right. That is different from my position. The reason that's different from my position is because I have no way to appeal the order short of actually bringing Article 78. So I don't know that they have the authority to just tell me we don't want to listen to you. I'm not saying that they do not have the authority. I haven't looked up matter of Dondi v. Jones. I'm simply saying I think that's likely. I think that's my position is likely correct, just logically, because there's no other way for me to bring this application. We declined to exercise our discretion. So basically, or to grant the relief petitioner seeks here is well established. Although litigants not surrender their First Amendment rights to the courthouse door, those rights may be subordinated to other interests that arise at the trial setting. United States v. Trump. Well established. Well established. Oh my gosh. Well established. You know, it's well established because there was a decision against Trump in the DC Circuit Court. Very well established. Wow. That's a lot of real firm New York law based on New York Constitution. Very firm. Aggravating. In the federal restraining order decision, the Circuit Court weighed the three key questions bearing on the entry restraining order against a criminal defendant. See, now they're just going to fixate here everything on the federal restraining order decision, meaning the DC Circuit Court. This entire decision is basically a restatement of the DC Circuit Court, which I argue cannot even be relied upon by any court here. It cannot be argued, it cannot be relied upon because the DC Circuit Court is operating under exclusively the First Amendment. But this gag order entered here in the state of New York in a state court by a state judge must comport with New York law, not merely federal law. So yeah, the DC Circuit Court, they have to comply with federal law. They don't have the extra hang-up of New York law. Judge Merchan, however, does have that extra hang-up because he has to make sure it's not just meeting this yardstick, but New York constitutional law. And the Court of Appeals has said that New York constitutional law and New York constitutional First Amendment protections, which they actually call it Article 8, Article 1, Section 8 of the Constitution, which, for the record, in case you're wondering, predates the First Amendment. That's how old that sucker is. So that Constitution, those rights of freedom of speech and freedom of press, which predate our federal constitutional rights here in New York, that they are stronger than the federal counterpart. Stronger, more protective of individual civil liberty. So I'm not sure about the propriety of the court, respectfully. I'm not sure the propriety of them relying on the findings that were used in a jurisdiction that has a lower threshold to substantiate the legitimacy in a jurisdiction which requires a higher threshold. And you can't just rely on what the DC Circuit Court says and says, oh, yeah, well, they reached this conclusion of law, so we can reach the same conclusion. Particularly so because the DC Circuit Court's rationale that they employ, that there is such a thing as offsetting First Amendment rights because of the state interest in the fair administration of justice. Well, that notion of there being a state interest in the fair administration of justice has been rejected altogether by the Sixth Circuit. They say there's no such thing. And when we talk about fair administration of justice, that's talking about Sixth Amendment rights, protecting defendant. And that respectfully, if the government doesn't like the way a case is going, no one cares. Go cry to your mother. No one cares. So that's the Sixth Circuit's perspective on it. The DC Circuit's perspective is there is such a thing. That's just how they feel about it. For one reason or another, that's the conclusions they reached in DC. Now you come to New York, and New York wants to say, well, it's Trump there, Trump here, but the fact of the matter is, you have a higher yardstick here. Higher yardstick. Federal Constitution, bare minimum threshold. Bare minimum. Which is part of what I was drafting in my papers today. that when you have a conflict here between two circuits, and one circuit is more protective of First Amendment rights than another, and we are in the state of New York, where our Court of Appeals, the highest court in the land, has ruled that the federal protections are bare minimum thresholds, and that our protections here in New York are higher. That as a bare minimum, logic dictates that must indicate that whatever that bare minimum threshold is anywhere in the country, that New York will at least match that. So imagine when we're trying to figure out, do First Amendment rights apply? I'm going to make up a total hypothetical here. Let me just take it away from this case here, just so you can understand logically what my point is, because I think this is an important point that you likely have not heard anyone say, only because I've never heard anyone say it before. I came up with this, but to me, the logic behind what you're about to hear from me is very, very sound. Imagine there's a dispute, okay? Does someone have a First Amendment right when they go to Uganda? Will the state of America, the state of the country, will they defend this person's rights? Do we respect someone's First Amendment rights so much that when they go to the state of Uganda, that if they get arrested there, I'm going to make up a total hypothetical. This is not true. Don't quote this. I'm just trying to give you a theoretical situation where you might see, let's say, in theory, let's imagine there's a split here. Okay. So let's say you have a person who goes to Uganda and they say, well, I have a First Amendment right as an American, so I'm going to make these statements that are illegal here. And he gets arrested. Now he looks to the American government and says, hey, you got to get me out of the situation. I was relying on my First Amendment rights. Okay. And let's assume that there's a split in the circuits, where some circuits say, yeah, if you try doing that in a foreign country, we will protect you, because that's how dear we hold First Amendment rights. Another circuit says, no, to hell with that. You're going to a foreign country, go follow, when in Rome, do as the Romans do. And everyone knows the Romans are kind of queer, so you got to do whatever they're doing. And it's not our job to defend you just because you decide to start acting like some hotshot America in Uganda. So we don't have a duty to do that. So now you have a division between these different circuits. One circuit saying we will protect you, another circuit saying we will not protect you. Okay? Now, along comes New York, and we ask the state of New York, would you protect them? Well, what does New York say? New York says the federal Constitution is a bare minimum threshold. Our protections are higher than what the bare minimum threshold of the federal Constitution is. Does not logic not dictate that if they say we will not protect you, we're not going to protect you, it doesn't cover this person who wants protection? But what is that? What's the outgrowth of that? That means that the federal Constitution is not what's protecting you. It's not, it's not the state Constitution protecting you, because in this other circuit, they say they would afford you that protection. So now in this context, New York is less of a protection than the federal Constitution. The federal First Amendment rights would be broader than New York. Well, New York says it's a bare minimum threshold. And that is why I came to the conclusion that when New York makes the claim that that our protections in New York under the New York Constitution are broader, and that the First Amendment is just the federal First Amendment is just a bare minimum threshold. In order for that to actually have manifestation, have any legs to it, it must mean that when you have a split and one circuit says we're not going to protect the First Amendment rights here, another circuit says we will, in order for New York to keep up with the party that says we will, they have to take that more protective stance under the New York State Constitution. Otherwise, New York State Constitution is less of a protection than the federal Constitution, than the federal First Amendment rights are in this circuit that is protected. So in other words, what I am saying is that when New York makes that statement, which it has, the Court of Appeals, the highest court in New York has said, this is a higher standard, more protective. In order for it to actually be more protective, at the bare minimum, as a bare minimum, New York State Constitution means that New York law will embrace whatever is the most interpreted the broadest protections of First Amendment rights in the country. Otherwise, it's not more protective. It's no beggar. It's worse. New Yorkers are less protected than someone in Circuit X, where they give that protection. So what are you talking about? How are you making the claim that it's more protective? It's just not true. In order for it to be more protective, it has to be at least as protective as any circuit would be. Whether or not it's the Second Circuit, which is where New York is, it's a foreign circuit across the country. It has to be more protective than it has to match their protections. And only by matching their protections can they proudly say, you know what, no matter which way a circuit's going to interpret this, we're going to go along with that. That shows, you know what, we're not just going by the First Amendment standard. We're going to match that protection level of First Amendment standard, no matter how it's interpreted across the country. Boom. That's now showing that you're as protective as anyone can be. And that's a minimum threshold. Otherwise, it's not even a minimum threshold. It's a threshold higher than you. So that is how I'm interpreting the phrase minimum threshold. And that is how I am urging the court to recognize that because there is a split between the DC Circuit and the Sixth Circuit on this concept as to does state administration of justice, the prosecutor's interest in getting someone convicted, which the DC Circuit Court says, yeah, that can sometimes outweigh your First Amendment rights. And the Sixth Circuit says, there ain't no such thing. It's crap. It's not true. The only interest in justice is for an individual who's a criminal defendant and not for the prosecutor. That New York must embrace that more protective stance and disregard the holding of the DC Circuit Court. That is what I wrote in my papers today. So I'm not going to share with you my papers tonight. It'll take too long, and frankly, most of it's not my work. Most of it is Ron Baruti's work. But that was part of what I was incorporating into the papers he was creating. All right. Anyway, moving forward here. Oh, warm in here. Give me a second. Just want to get the AC on. Hopefully, I don't lose it. So much better. Okay. Make sure I miss anything. All right, so what we got here? Move along. So in the DC Circuit Court, the court weighed three key questions bearing on the entry of a restraining order against a criminal defendant. One, whether the order is justified by sufficiently serious risk of prejudice to an ongoing judicial proceeding, which that should never be. But two, whether less restrictive alternatives would adequately address that risk. And three, whether the order is narrowly tailored, including whether the order effectively addresses potential prejudice. The federal restraining order is nearly identical to the restraining order, nearly but not exactly, issued against petitioner in the underlying criminal case. Petitioner brings this petition because he disagrees with where the circuit court drew the line in balancing the competing considerations of his First Amendment rights to free expression and the effective functioning of the judicial, prosecutorial, and defense processes. Now, they cite Landmark Communications versus Virginia. Hack! That wasn't supposed to be. They cite Landmark Communications versus Virginia. Okay. Which is a case that Mershon cited. Weighing these concerns, circuit ultimately concluded that given the record, the court had, quote, a duty to act proactively to prevent the creation of an atmosphere of fear or intimidation aimed at preventing trial participants and staff from performing their functions within the trial process. Yeah, that's why he's doing it, to stop them from being able to do their job. Because if he does that, then they won't be able to do their job. Ridiculous. This court adopts the reasoning of Circuit Court's federal restraining order decision. Of course you do. The federal restraining order decision properly found that the order was necessary in the circumstance holding that Trump's documented pattern of speech and his demonstrated real-time, real-world consequences pose a significant and imminent threat to the functioning of the criminal trial process. Hey, here's a newsflash for you. Judge Chutkin and the DC Circuit Court, they didn't have no evidentiary hearing either. Nobody knows any of this is true. Nobody knows any of this is true. That his statements are having real world consequences. Nobody. There's been no hearing, no determination other than just a conclusory finding that, well, if you say there was an increase in his tweets and there was an increase in activity we don't like, we are going to assume that A is causing B rather than the two being thoroughly unrelated. Even if he puts a tweet out in October and somebody does something nasty the following March, we're going to assume that that tweet in October is what generated that activity in March. Because there's no correlation in time. In fact, even if the negative activity happens six months before he sends a tweet, we're going to assume that it's his conduct, that his tweet that caused that conduct which happened months beforehand. That's essentially, I mean, for all they looked at the causal link, they don't even know that his tweets precede in time the conduct that they are complaining of, the conduct of third parties that they are complaining of. First, the circuit court concluded the petitioner's directed statements of potential witness concerning the participation in the criminal proceeding posed a significant and imminent threat to their willingness to participate fully and candidly. Yeah, really? All of them? All of them? Every one of them? Even Michael Cohen? Really? That's fascinating. And that courts have a duty to shield witnesses from influences that could affect their testimony and undermine the integrity of the trial process. For anyone to reach this conclusion, and respectfully, anyone who could actually reach this conclusion about Michael Cohen, I am sorry. That is just a finding of fact that I cannot even understand how that's made in good faith. I can't. Now, maybe they didn't focus on Michael Cohen. That's likely the case. Justice Merchan properly determined the petitioner's public statements posed a significant threat to the integrity of the testimony of witnesses and potential witnesses in this case as well. The constitutional objections the petitioner lodged against the restraining order restrictions on his statements relating to Mr. Colangelo and Mr. Merchan are unavailing. Notably, petitioner does not argue that the restraining order has impinged upon his Sixth Amendment rights. I don't know why you didn't do that. That's a good question. Trump doesn't even claim that it's affecting his Sixth Amendment rights. Why? Why would you not make the claim? Why? I read this and I was like, does that mean I can't make the claim that it's hurting his Sixth Amendment rights? I'm in a weaker position to make that claim. I still think I can. It might be harming his Sixth Amendment rights in ways he doesn't realize. It definitely harms that part of my paper. It's not going to kid you. Or that he's unable to receive a fair trial because of the restraining order. How do you not say this? How do you not? How? I read this and I'm like, what the hell did they claim? What's in Trump's papers? Instead, he argues the restrictions of his statements relating to any real proceeding posed by Mr. Colangelo and Ms. Merchan's actions and employment. Ms. Merchan's actions and employment history restrict his ability to engage in protected political speech and may have some adverse impact on his campaign. Yep. Made it all about, see, this gets me mad. And I've said this before. Like I said, I'm going to blame Trump on this. You might get mad at me for this. I'm going to blame Trump. Why is this your argument? Why are you making about your campaign? How is that going to be availing? You think that a New York court is going to sit there saying, oh, we're worried about your campaign? Even if you're potentially, in their opinion, that you're potentially impacting a criminal trial for your campaign. I mean, I can't even imagine how they wrote this in good faith. I mean, I can understand how they wrote it, but think through who your target audience here is here. How does that make that doesn't make it. I mean, I agree with the fact, and I'm sure they put in their papers, that there is no type of speech that the Supreme Court said over and over again, that political speech deserves the strongest protections out of any other form of speech. And I'm positive that his tweets on Truth Social, whatever they call them, his truths are political speech as defined by the founders and virtually every Supreme Court justice who ever wrote anything. Okay? As a matter of law, in my opinion, I think that there are probably very few Supreme Court justices in American history who would look at his tweets as anything other than political speech. That's just not your strongest argument. The arguments I presented are far more effective. It's far more on point as to no, you see, and this is, and what would if he would win? If he would win, what is the win? The win is basically for himself individually. All of a sudden, when you reduce your argument to this argument that he apparently made, at least this is what the court is reporting he made. I haven't seen it, but we can infer this from the decision. That he made it all about his specific tweets. What does that do? It means now we got to start looking at your tweets and going through them tweet by tweet by tweet by tweet by tweet and say, is this a political statement? Is this a political statement? Is this a political statement? Some people saying yes, it is. Some people saying no, it's not. Whatever. I think all of them are personally, but I'm not the final arbiter here. I'm not the finder of fact. So now you're sitting here, and all of a sudden you gave up the game before you walked onto the field. Because instead of start going into like whether the nature of his truths are protected, attack the attack. Come after the legitimacy of even raising this as a potential thing that can happen to a criminal defendant, even if he was not running for office. There's so much fixation from Trump's team here about him being Trump, rather than him being a criminal defendant who's being wronged by the court. And that's a far more compelling argument, and it's also an argument which would, knock off this concept of a gag order in criminal cases across the country. That's an argument for the country rather than an argument for yourself. That's what's so bothersome to me, because the critique of Trump is that he's all about himself, he's not about the country, and these papers are, I think, weaker than they should be because they're much more about Trump specifically rather than the Constitution as a whole, and how this is basically like as if some of the judges who handle this, obviously not the New York judges, but some of the judges outside of New York who looked at this basically took a rogering to the Constitution and said, we're going to do this. We're justified in doing this because it's Trump. So what did you do? You went to their playing field and you said, I'm going to play by your rules and say, no, Trump has this right. Trump can do this. Trump is running for office. Trump is allowed to do this. Instead of just saying you just rogered the entire Constitution because you're so afraid of this one dude. And what are you even thinking? And you Frankensteined these SCOTUS decisions to justify and pretend that they're saying something that everyone who ever read them before knew they were not saying. It's an argument that's got nothing to do with Donald Trump or what he's truthed or what he's posted or what his audience size is. It's purely about, does the court have this power or not? It's a much more powerful argument to make, much more winnable argument to make. And that's the argument that I made. I don't understand making this argument based about Trump's unique status as a presidential candidate, that his speech is political speech. I think this is a stupid approach. I shouldn't say stupid. If you want to put this in, this should be like argument number 7 or 4, but not top 3. And you want to know one argument that should be in there, which apparently wasn't? 6th Amendment. You start going on and on and on about how this is just a violation of the Constitution based on every single thing that the Supreme Court has ever told us about your First Amendment rights, your 6th Amendment rights, and your 14th Amendment rights. That's what you do. Not sitting here saying I'm special because I'm the presumptive GOP candidate. It's like, it's stupid. It's stupid. I'm reading this and I'm like, yeah, I understand why he lost. I don't want him to lose. I think it's wrong that they're sitting here embracing the DC Circuit Court's Frankenstein editions of Supreme Court decisions and saying, oh yeah, this is a totally smart read about what Shepard v. Maxwell says. Oh yeah, it totally says that we're allowed to gag someone. Oh yeah, sure. Landmark Communications, which basically said, oh hell no, never restrict free speech. Yeah, that's totally on board with this. Instead of attacking the read and the just utter perversion of Supreme Court precedent. You said the argument that apparently was made, I don't know, I haven't seen his papers, but interpreting what this decision says, the argument that was apparently made is like, oh, he's special. He's running for office. It's political speech. So even though you're otherwise right, you otherwise would have a right to do it, but because he's special, now you can't do it. How is that a winning argument? Oh, great gay gag. I don't know what this means, but thank you, Brian. We find that Justice Merchan properly weighed petitioner's First Amendment rights against the court's historical commitment to ensuring the fair administration of justice in criminal cases. The court's historical commitment to ensuring fair administration of justice? Really? Where else are we doing this? Where else did that happen? I don't know where that happened. And the right of persons related or tangentially related to criminal proceedings from being free of threats, intimidation, harassment, and harm. And there you go. That constitutes decision order of the Supreme Court. I read this and I was like, I understand why he lost. I get it. I understand it. I'm sorry, my arguments are infinitely stronger. Infinitely stronger. It makes me much happier that I filed this, because I'd be very bothered by the idea that this was the whatever. I'm not looking to disparage any attorneys. I don't know why the arguments I made were not made. They could have made the exact same arguments I made. Anyway, so that's what we got there. But I told you I have huge news, good news, great news, awesome news, amazing, amazing, amazing news. The amazing news I have for you is I think we may. You're sitting down? You're sitting down. Okay, good. The good news I have for you is that I think we may have found a way to bypass a lot of the procedural issues that I'm having. I had a lengthy conversation with my attorney today, and because of attorney-client privilege, and so that he doesn't yell at me, I'm not going to go into detail about exactly how the conversation went down. But we basically recognize a problem. I still have not been told when the final date of submission will be for my pending Article 78 application or the motion that we brought for injunctive relief. Now, the more I look at this, the more I question if they're ever going to give me a date. They can give me a date sometime in September. I don't know when they're going to give me a date. They told me I would have it. Initially, they wrote that I was going to be, everything was returnable on May 6th. Then they started arguing with me about whether they can accept my reply, as well as Good Logic's reply, because those are two separate replies. There's me individually, and then there's Good Logic LLC, which is represented by Ron Baruti. And they didn't want to accept our replies. We had to make an application to the court. The court said we will accept it, but the other relief you asked for there with NICEF, you can go jump in a lake on that. We're not giving you that. And essentially saying, okay, we're going to let you know one day when this is marked final. And I'm like, why do we need a date for this to be marked final? It's supposed to be marked final on May 6th. And then you're going to tell me then at that point, I can sit there and submit an application to be able to orally argue this. I'm not even getting oral argument on my motion. I'm just like, this is not what I thought. This was not what I thought it was going to be. And every day, and I was talking to Ron, and we were both very frustrated because we're just like, they're just going to wait out the clock on this. Like, how? And I was like, you know what? Today, my rights are affected. Today. Every day, my rights are harmed. Every single day. My freedom of the press is harmed. If we looked at it like someone being, that your civil liberties are being, like, as if your civil liberties are protections from being punched in the face. It's like, oh, okay, tomorrow, here's another punch in the face, Joe. Pow! Here's another punch. Pow! Every day. Every day is a new punch. Am I ever going to get relief for that punch? No. We're not going to get back time. That's never going to happen. That's never going to happen. And I was just like, so he started talking with me about procedure and how it just doesn't make any sense that this is constitutional. Because the more we thought about it, the more we recognized this is basically an ongoing violation of my due process rights. Even if you want to tell me I'm wrong, tell me I'm wrong. But sitting here leaving me my rights in a stranglehold where I can't get a final adjudication here, and until I get a final adjudication here, I'm not supposed to be allowed to go to the Court of Appeals. So basically, they can sit here and just strangle me out until it's moot, because the case is over and it's like, all right, well, it's moot. We're not deciding it anymore. That cannot be that itself. The delay is a violation of my due process. It's a violation of my due process rights. And every day it's another pow, punch in the face. This cannot be. It doesn't make sense. And I sat there and I was like, we have to figure out how we get to the Court of Appeals, because that's what we really need. Again, there's four appellate division. The appellate division is broken up into 4 departments. There's one for Manhattan. The first department is for Manhattan, or they call New York County and the Bronx. Second department is the rest of New York City and a couple other counties. And then you have third and fourth departments. And I was like, maybe we can appeal this to a different department, because it's like, there's got to be something that we can do. It doesn't make sense to me. And what we ultimately realized is I started ripping apart, and I was like, maybe we really do it. We made a joke about filing an Article 78 on the Article 78, but I was like, maybe we do. Maybe we have to actually file an Article 78 to be heard. And I was like, where would that even be filed? Like, how do you get that relief? Like, what steps do you take? And so I'm filing a second Article 78 against the first department. That doesn't make any sense. If I'm complaining about the way the first department is basically snuffing the life out of my application purely by withholding a dispositive decision, they're refusing to give me a final decision, and it's that refusal. It's not the rejection. If they would just say no, then I can try and appeal to the next level. They have the power to say no. They have the right to say no. That's in there. They said no to Donald Trump today. They could say no to me also. My application started 2 weeks before his. I think, from what I was told. I don't know. His is under seal. Based on what I heard, he got a decision already. I'm sitting here waiting. Does that mean they're more scared of like how to actually get rid of my decision? I don't know. I have no idea. They will not tell me anything. And that's part of the violation of my due process rights, right there. So we look closer at Article 78. And I was like, maybe there is a basis for me to get in to the Court of Appeals. And we start going through, and then the other thing we looked at is the idea of, instead of Article 78, appealing that forward decision against me to the Court of Appeals. Now, to get into the Court of Appeals, which is the highest court in the state, to get into that court, there are situations where you can appeal as of right, or you can appeal with permission from the court. And I sat there and I broke down with him, and I was like, does this section apply to this? Can this section apply to us? And this, and we're breaking it down. We're killing ourselves here trying to figure this out. And then we found it. We finally found it. I was like, because there's a right of appeal, not even permission, but a right of appeal. When a judgment is non-final, which that's what this is, because I don't have a final judgment from the appellate court. When it's a non-final judgment, but it has the effect on the final outcome. And this is what I realized. And Ron's like, yeah, that's it. Because this is an ongoing, daily, hourly suffering that I have, this is not just one big giant constitutional violation. This is a constitutional violation that is I'm suffering every single day. So that decision that was issued by Judge Rosado, where she says, we're not granting you the interim relief, let's assume I were to win, despite her initial decision. Let's assume I were to win a week from now. Case is still ongoing. Think about this for a moment. Case is still ongoing. Let's say a week from now they say, oh, you know what? Joe is right. He's right. And we're now going to take the gag off. Will that get back from me the harm I suffered yesterday? Will that get back from me the harm I suffered today? Will that get back from me the harm that I suffered tomorrow? Or all the days between today and when it's ultimately adjudicated? And the answer is obviously no. That harm will never be redressed or remedied in any way, shape, or form, which means that this decision by Justice Rosado, I don't know, I was arguing with Ron today as to when it's considered judge or justice. This decision that was issued by the Honorable Lynette Rosado has the impact that ultimately, when I prevail here, the relief I'm able to get is going to be severely impacted, because the relief I'm going to get next week when I win this case, or 2 weeks from now when I win this case, is never going to get me back the harm I'm suffering today, or the harm I'm suffering tomorrow on May 16th, or the harm I'm suffering on May 17th. So even when they try and remedy it for me on May 23rd, that's not remedying the problem that I'm having on May 16th, May 17th, May 18th. And when you have, which means that it is unremediable, remediable, and accordingly, in the way we understand Court of Appeals, that gives us a right to appeal as of right and go zoop straight to the Court of Appeals without having to wait for a decision from the First Department. So I don't need to hear the First Department tell me, sorry, we're rejecting you like we rejected Trump, or sorry, we're not going to listen to your case for the next 4 months, or whatever other sorries they may be giving me. But the huge news I have is that we actually contacted the clerk of the Court of Appeals. And they said, you can file here. And she was very helpful as far as going through the procedure and said, you can file your application here. And if in fact the court agrees with us that we get in there as of right, potentially, this might get redressed within a couple of days. And if the Court of Appeals rejects our claim and says, no sauce for you, no soup for you, no soup for you. If the Court of Appeals does say that, which I'm hopeful that they won't, I'm hopeful they recognize the sanguinity of the arguments I presented in my papers. But should they not see it the way I see it, and they reject me altogether, saying, sorry, you're not welcome here, that now opens a door. At that point, I believe, we can apply for cert from the Supreme Court of the United States, which means that for purposes of working procedurally through this whole thing, despite the inordinate delays I've been facing in the First Department, it's very possible that within the next week, if I don't get relief from the First Department, that we can be looking to go to the Supreme Court of the United States. I thought I was going to be strangled out here in the First Department. This is a massive finding on our part. And the clerk in the Court of Appeals was very helpful in walking us through the process. Certainly not making any promises. She doesn't know whether it will be successful or not, but was very helpful there, which was nice. Very, very nice. So there you go. It's not a matter of cluing anyone into my tactics, Matthew. It's not like anyone. It's not like there's any. It's the procedure is either permitted or it's not. There's nothing anyone can do about it. The question was how to just to figure out the basis for us to get in there. And I got to tell you something. This is such complicated procedural law. It's so complicated. It's really complicated. So there you go. There you go. That's what's happening. That's the big news. But I'm hopeful that we're going to get relief. And I'll tell you this much also. Court of Appeals is in Albany, New York. That's a very different kind of judge. A judge in Albany, New York is very different from a judge down here in New York City. Typically. Not always. Not always. I don't know. That's a very different kind of judge. And I'm hopeful that they will be receptive to my arguments and say, this gag order doesn't comport with New York State constitutional law. That is what I'm hopeful of. We will see. We will see. If and when there's a portal that's created where you can find our filings, I will share that with you. I am not sharing my filings with you guys today. I'm not going to share it with you tonight, but I do expect to share it with you in the near future. And I will tell you that Ron Baruti was working his tail off to get these papers completed to submit a proper application to the New York State Court of Appeals. I've never tried going to the Court of Appeals before in my 25 years. I've never tried going there, and I never imagined that the first time I'd be going there, it would be in my individual capacity. Hot diggity. But speaking of things I never imagined, I'm just going to share this with you. This case here. Case you probably never heard of before. Harrow versus Department of Defense. Harrow versus Department of Defense. Which seems like a nothing, unimportant case. No one cares about it. It's basically there's a 60-day deadline, and the petitioner in this case never saw the email, which started the clock running for him, and until like 7 months after it was sent to him. And the question here is he going to lose his entire pension or not? So he seems pretty sympathetic. It's Harrow versus Department of Defense. Why am I calling this attention to you? Because the petitioner's first name is Stuart Harrow. And I want to wish Stuart Harrow the very best of luck in this case. Because I literally know this man for roughly 40 years. And all of a sudden, a mutual friend of ours, who's an attorney, sends me this. He's like, did you see that Stewie's going to the Supreme Court? And I was like, no way. No way. Now, I haven't seen this guy in 40 years. He was older than me. I thought he was like 10, 15 years older than me. I saw a picture of him. He looks like he's 100. Nicest guy in the world. Like, so ridiculous. I can't even tell you how nice this guy is. He's really like the nicest. Just would never say a rude word to anyone. He's just so nice. Really the nicest guy. So I just want to wish you, Stu. I know you probably never heard of my show. You probably haven't thought of me in decades. But I'm going to wish you the best of luck and success here. So there you go. There you go. Go get him, Stu. Let's dig a tunnel there and wear the old tracksuits. Yeah. Never share. It's not a matter of sharing. It's not a strategy. It's not like, oh, I'm going to do this and then whatever. It's simply like, this is the step. This is the next step. This is the next step. This is the next step. And I was like, I don't know how to get past this step, but now I do. And this is a big breakthrough. It's not like the district attorney can do anything about it. It's not like the first department can do anything about it. It's not like the clerk of the first department can do anything, or Judge Merchant can do anything about it. No, it's a matter of like, this is the next step. They're all getting noticed anyway. They're getting noticed to our papers. So it's not like it's going to come as a surprise to anyone. Surprise, mother. Surprise, Justin Tucker. Woohoo! Go you. Thank you, Kathy. Thank you kindly. And if the appeals gives you a date, New York City finds out and gives you a date also. A date for what? A date for what? I mean, I know what you're trying to imply. On what basis? By that logic, I never should have filed anything if that was going to be my fear. Dang, I thought news would be finally getting traction soon. I do hope they relieve me as well. Road trip to Albany. Yeah, I don't know. I'm not sure. I think I have to go to Albany. I think I go up there. Let's see. We'll see. We will see. Woo! I will tell you this. The more I think about this, the more I want to get that DC Circuit case overturned, because that's going to be precedent. And that's still ongoing. Even if I win in Albany, I'm still thinking I want to go get that thing overturned. I have to get standing in DC. I'm going to have to get standing. But I am thinking about it. I don't like that DC Circuit case being out there as good law. I don't think it is good law. I don't think the justices of the Supreme Court. I don't know what's happened with that case. I mean, I assume it was appealed. What happened with that? Was cert denied? I'm curious about that. I am curious, but I don't know that his arguments were framed properly. I have questions. As to whether or not they were framed properly. And if they're framed poorly, you ask the wrong question, you're going to get an answer you don't like. You have to know how to ask your questions. With that, you're all caught up to me. And I think it's time for us to start looking at what Mikey Cohen said today. What did you tell them, Mikey? What did you tell them? One of you who's sitting here in the audience told me that this went well today. I have not looked at this. I have not looked at today's testimony from Inner City Press. I was a busy man. But I'm going to look at it now. You're all going to look at it. Let me check over. Speaking of being a busy man, let me check over at in the Rumble Ghetto. Texas 47. Sounds like the courts are seeking to create mootness. And the only way to proceed is to make it clear that the courts, clerks, judges will themselves suffer a penalty for delay. There's no way for me. I'm not certainly going to be visiting any sort of suffering upon the courts or the clerks. But we found a new way to skin the cat. Joe, you take this, what you just said in this stream, this recording, and you submit to Justice Sotomayor your district for reciprocal sanction of the delaying judge, his pain for your pain. I'm sure Justice Sotomayor will be very sympathetic to that. You would hope. You would hope she would be. I don't know. I will say this, by the way. You might notice I haven't shaved in a while. I'm in a period of mourning. So I had my regular beard here, and now this part's growing in. And then the more I'm seeing it, the more I'm thinking, I got to even this out, this part and this part. The more I'm seeing this, the more I'm thinking, I think I'm going to stick with like the full beard instead of the trimmed out beard. I'm really liking the full beard look. I think so. I used to think it wasn't connected well enough, but I think it's good. I think it's pretty good, actually. I guess we're at this spot right there. Yeah, I know what I did. I know what I did. That's right. New York is dry run for DC and all gags. I hope so. Let's see what we can do there. All right. Inner City Press. Let go. Let's go. Let's see what happened with Mikey. Oh, this is going to be going on. Can you finish by the end of Thursday? Oh, wow. Oh, wow. I'm really looking forward to this now. Blanche, can you finish this by the end of Thursday? I'm not sure. Oh, my God. Okay. I might do like a week of the good Lawgic players, like reading Michael Cohen. I never got to the cross-examination of Stormy. I really might make a play out of all of these things, because I'm starting to feel like this is going to be very enjoyable to read. Okay, so now we're still on direct here at this point. We're still on direct at the start of today's hearing. Today's New York criminal action. Trump is here, blue suit and tie of yellow or gold, talking to Todd Blanche in lead counsel seat at defense table. All rise. This is the people of the state of New York against the people of the state of New York. Definitely not what that is. I'm going to assume that this is a typo and not something the clerk said. Even though this is probably more true than they realize. But this is the people of the state of New York versus the people of the state of New York. May we approach. During the whispered sidebar. Trump leans to his left and speaks with his second lawyer, Emil Bove. Neschel is also in the conversation with the colleague behind her. Bring in the witness, then the jury. Continued direct examination. Prosecutor, put up People's 39 in evidence. It's an email from Jeff McConney to me. Get me the invoices. You spoke to Alan about. Thanks, Jeff. On February 8, 2017, did you visit the White House? I did. President Trump asked me if I needed money. I said, no, I was okay. He said, be sure you talk to Alan. Did you take any photos? Why? Yes, visiting the White House. Because let's remember that he basically was in the White House. Trump had just been sworn in a couple of weeks earlier, right? He was sworn on January 20th, 2017. This is only February 8th. So that makes sense. Photo of Cohen at briefing room podium, People's 254. In my calendar, it's my calendar, about February 8, 2017. And what's this? My reply to Jeff McConney regarding $2 signs I wrote. $2 signs I wrote. Please have the January and February checks payable to Michael D. Cohen, Esquire. Jeff replied, please invoice me. I asked him to remind me of the monthly amounts. Why? See, this sounds like it's part of his regular payment. This sounds like it's part of, this does not sound like he's being repaid for loans. Those of you who may have missed yesterday's testimony or some of my coverage of his testimony, just to see we're all on the same page here. So there's a few defenses that Trump has. What is the claim here? Let's just remember, I'm going to summarize this very briefly, which is the claim is that Michael Cohen was trying to help Donald Trump win the election by giving hush money to Stormy Daniels. That's totally legal. Nothing illegal about that at all. But that when he was repaid that money from Donald Trump, that Donald Trump had a duty to report that as a donation to his own campaign, and he did not report it. And they say that his motivation for that was to keep it secret, because if it was publicly reported, people would see that he's paying this money, this hush money, to porn star. And that's the 34 crimes that he committed every time he recorded it as not being an election donation. Recorded in his own books. So he's falsifying his own business records to hide that crime of federal election reporting violations, I guess. I don't know. FEC violations. Now, his defenses are he never paid Michael Cohen anything. The monies he gave to Michael Cohen were to part of his regular payments. He was his lawyer. So he gave him his regular payment. And none of that was part of his donations or his paying back a loan. In which case, as his lawyer, it's his private lawyer. Why the heck would that come from his campaign funds? If anything, that would be a violation. Using his campaign funds to pay his personal lawyer, that would be a violation of the finance law, of campaign finance law. So that's why he didn't report it as part of his finance, because it's just payments to his personal lawyer. So there's no repayment. There's no repayment here. That's first. Secondly, that he that if this is deemed to be repayment of the loan, that this money that was paid to Stormy was not to help him win his campaign, but for other reasons, like to keep it from his wife, to help his public PR, the way he's been trying to protect his public PR for decades before he ever ran for office, in which case it's got nothing to do with his campaign. And even if he paid back the money, it was not paying his lawyer, but he was just paying back the money. In that case, that's got nothing to do with his campaign. He's spending that money silencing someone who's going to hurt his PR in general. Same way he always had been worried about it. Just because he's worried about his PR in October, November of 2016, he also was nervous about his reputation in October, November of 2006. He's always been. He's been in the public spotlight for years and years. And in fact, this guy, this admitted perjurer, Michael Cohen, had made payments for years on his behalf before he was ever running for office, had been involved in many times, many deals, negotiated many situations where he was trying to take care of his PR that had nothing to do with his election. So all someone assume that this one is specifically for his election, kind of ridiculous. All right, so those are his defenses. So now the DA has him on has Mike Cohen on direct, and he's trying to establish the payments that came in, and he's obviously going to try and tie in and claim that this was repayment of the loan. Mike Cohen had loaned $130,000 to Trump via giving that paying off Stormy Daniels for him. So I asked him to remind me of the monthly amount. Why? I didn't have the document with me, and he didn't have a retainer either. I did not, so I created an invoice and emailed it. Dear Alan, pursuant to the retainer, had you in fact rendered any services in those 2 months? Objection overruled. Was this invoice a false record? Yes. Oh. So you know how we know he's trusting? Because he's admitting that he created false records. This is the stupidest case in the world. So he's like, yes, I did charge him as a lawyer, but it really was repayment of the loan. Wow. And the other invoices were false? Yes. Did you receive 11 checks in 2017? Yes, ma'am. What is Exhibit 4? The check sent to me for $70,000 for January and February because he was getting $35,000 a month. It had a stub attached to it, one of the stubs. Were the descriptions here on this check stub false? They were. Who signed them? Eric Trump and Alan Weisselberg from the DJT Revocable Trust. So that's not even Donald? It's someone else? Why is he the criminal defendant? The March invoice was false too? Yes, ma'am. That's another defense that Donald has. Like, why is he the criminal defendant for things that were signed by Eric and Alan Weisselberg? Who signed this check? Don Jr. and Alan Weisselberg. April was the description on the check stub. False? It was. Who signed this one? Donald J. Trump. Did you get 8 more? Yes. The invoice was in the month of June, 725 Fifth Avenue. Dear Alan, Cohen says he cut and pasted. This is for 2 months because the check for May was lost. Who signed this one? Donald J. Trump. And July, 725 Fifth. And August, September, also false? Yes, ma'am. Put up 37I. October invoice, also false. Yes. 37J. November, false? Yes. 37K, December, 725 Fifth Avenue. Dear Alan, false? Yes, ma'am. Was this the last invoice you sent? Yes, because now I had been reimbursed. This check, who signed it? Donald J. Trump. Ooh, he signed the check. He signed the check. In 2017, did you do any work for Mr. Trump or his wife, Melania? Minimal. So you did do some work. You're even admitting you did some work. One matter from Mr. Trump, Summer Zervos or something about the likeness of Mrs. Trump. Did you receive emails from Alan Garten? Very minimal work. How many hours did you work for Mr. Trump in 2017? 10. And in 2018, as a result of Stormy Daniels going public, Mr. Trump wanted arbitration action to be filed against her. I was contacted by Eric Trump and Mr. Trump. I worked with Larry Rosen. Then why were you hired? How is it that he's doing minimal work and he said he was all excited that he was hired to be a personal attorney for the president? I don't understand any of this. Please do players of this trial. It would be great. I did do players on Saturday night. Just check it out because we had a lot of fun. All these trials are giving me gas. Oh, it's just reality. Can't help you. CNN brought in 2 lawyers to do a performative reading of the trial transcript. Kid you not, Google it. This is so stupid that this is not being publicized. We need to do plays. Have you reached out to Tom Fitton, Judicial Watch, big in the transparency oversight FOIA space, responsible for Clinton Sox draw presidential record case? Stay strong and keep up the great work. I haven't. I'm trying to remember. I think I did at some point. I don't remember hearing back from him. I think I did. I appreciate you recommending that, Turk. I think I did. And Doug. You need to go through Cohen tic-tac-toe in Pelosi words videos. That dude is so unhinged and creepy. It's amazing. Now you have me all curious. What does that mean? TX47 says, Justice Sotomayor has an extremely strong history of substantial support for freedom of speech cases. Actually, the best of the justices to hear this pleading for relief. That's why I specified that. Interesting. Interesting indeed. All right. That gives me some hope. Scorpid Black Dragon says, Joe, have you noticed how Cohen resembles Brett Spiner, the Star Trek actor that was cast as the android Data? Now that you say it, he looks like a fat version of him. I hadn't thought of that. I kept thinking that he looks like someone, and that might be who it was. Not bad. Not bad. Okay. Where was we? Did you monetize the position as personal counsel? Yes. 5 clients, $4 million. Also, Squire Patton Boggs. They pay me $500,000, bifurcated. I had offices in their space in New York and D.C. They wanted me on their letterhead. Did you get subpoenaed by Congress? Yes. About Trump Tower, Moscow. Did you have an attorney? Yes. Paid for by Trump Org, subject to a joint defense agreement. Did you make false statements to Congress? Yes, because I'm a big fat liar. Why did you make false statements to Congress? I was staying on President Trump's message that there was no Russia, which there obviously wasn't, but okay. Did you continue to lie and pressure others to lie about the payoffs to McDougal and Daniels? Yes. Did you speak with President Trump? Yes, through Madeleine Westerhout. Who's on these texts? Me and Keith Davidson. The joint defense agreement, who benefited from it? Trump lawyer Blanche, objection, sidebar. I think he's saying it calls for speculation. We say who benefited from it. Probably were a lot of people. Probably calls for speculation as to who's benefiting. After the sidebar, sustained. What was your understanding of who benefited from the joint defense agreement? Objection, overrule. Oh my gosh. Mr. Trump, his understanding. That's his speculation. How is that any different? His understanding is his speculation. Unless you can establish how he reached that conclusion. What's that rooted in? Well, it's my speculation. Oh, okay. Did you arrange to have Miss Daniels on the Hannity show in this period? Yes, but she did not go on. She went on Kimmel, but signed the statement before. Did you know the statement was false? Yes. Did you get an FEC complaint? Yes, McDermott, Will, and Emery firm replied. Was it false? Misleading. You dirtbag. He's such a dirtbag, this dude. Oh my God. What a dirtbag. This is to help you assess Mr. Cohen's. Oh, sorry. And this, big boss just approved me responding. Start writing and I will call you soon. It'd be a scoop. I don't know what that means. Oh, start writing and I'll call you. Okay. So slimy. Sleaziest guy on earth. Justice Merchant, jurors, this is to help you assess Mr. Cohen's credibility. Neither the fact of the FEC investigation nor the responses thereto constitute evidence in this case. Justice Merchan is a New York judge. And I'm a New York attorney, and New York judges are beyond reproach. Did you provide this to Jay Sekulow? I did. People's 217. What did Jay Sekulow write to you? He wrote, client says thanks for what you do. Did you speak with David Pecker? Todd Blanche asked to speak to prosecutor, then asked Justice Merchan for a sidebar, and he gets it. The information about AMI is only for you to assess the credibility of David Pecker. This is Merchan telling the jury probably. The information about AMI is only for you to assess the credibility of David Pecker. I told David Pecker that Jeff Sessions, because this all seems like classic hearsay. I told David Pecker that Jeff Sessions would take care of it. That's what President Trump had told me. Did you file for arbitration in California? We had a Trump or California lawyer file it. We served her new counsel. It was Michael Avenatti. Did Avenatti file a lawsuit for Ms. Daniels? Yes. President Trump required to sit for a deposition, so the NDA was stricken. What happened? Oh, my Venmo statement is ready. That's good. That's good to know. Phew. That reminds me, I should put this up, shouldn't I? Believe it or not, in the past week, while I have been fighting for your rights, for one reason or another, my sub numbers have not moved an inch. If anything, I think they dipped a little bit, which is very strange. It's very strange because people hear about my fight and they, at the very least, say, hey, I'd like to know how that's going on. I'd like to know what's happening with that, whether they're rooting for me or ponderously rooting against me and shilling for big government to clamp down on all of our individual liberties. But whatever it is, they tend to follow behind and say, hey, let's see what's happening. He's actually, like, you know, taking care of things here, or trying to take care of things. And yet, for one reason or another, I'm stuck in 96,500, mid 96,500 for the last several weeks. I cannot explain it. I don't know why. If anything, I imagine that probably some people are being unsubscribed from me. So this is my little cartoon that's reminding you, make sure you hit like and subscribe. Thank you kindly. Also, a little banner here. Those of you who are not in the chat, and it says, please like and subscribe. To support my legal efforts, go to www.givesandgo.com/ungag Trump. What happened in April 2018? A lot of things happened in April 2018. Can you be more specific? I was raided by the FBI. I was in the Regency Hotel at 7 a.m. Ton of people in the hall. They raided my apartment, my loft, and TD Bank, which had a safety deposit box I had just opened. They took my 2 phones. After the raid, President Trump called me and said, don't worry, I'm the U.S. president. There's nothing to worry about. Have you spoken to him since? No, because I basically showed him I'm a big, fat, stinking liar who happens to be a very sleazy attorney. Is he still admitted to practice? I'm not sure. When you get convicted of, when you admit, not convicted, when you're an admitted perjurer, you would think that would have an impact on your law license. And that's because that would be considered a detriment and not at all an enhancement of your law license. I didn't mean that sincerely. You would hope so. You would hope so. For the love of God. You would hope so. I'm still looking at my own beard as I'm sitting here covering this. Not kidding you. And I'm very torn about whether or not to keep it. If you could drop in the comments whether I should just come down to the regular or like that up there and even this out. I need direction. I should make a poll. That's what I should do. I'm probably gonna talk about this a lot more over the next week and a half. So I'm not shaving for the next week and a half. Spud says Robert Ray did a great summer stock version of this today. Did he? I don't know. What does that mean, summer stock, Spuds? What do you mean by that? I did insert myself. I'll trim the neck. Yeah, that for sure. I'm definitely going to trim this part out. I'm definitely cutting this part. That's... He's disbarred and lost his cab medallions. Oh, good. Okay, you're saying full beard adds weight, but here's the thing. What I don't like, the reason I'm thinking about keeping it is because I feel like it sort of gives me added jowls. I used to have what I considered to be like a carved in stone type of face, like basically my head shaped like home plate, which I kind of like. Strong chin over here, just I like it. And all of a sudden I'm seeing pictures of myself where it looks like my jowls are hanging over the bottom of my beard, like it's like basically my jowls became a beer gut on my face. I'm like, why do I have a beer gut on my face? Why does my face have a beer gut? That's not good. So I was thinking that cut was made my face look fatter. That's funny. That's really funny. Grow out the neck beard. That's what I'm gonna do. That's great. That was really funny. All right. What is summer stock? I'm still curious about that, Spites. What's summer stock? He acted it out? Oh. Did others reach out? Yes, they said he has your back. Maybe he saw the good Lawgic players. He's like, oh, I'm going to do it this way. Oh, I'm going to do it this way. All right. Here is 3 tweets from April 21, 2018. He was saying, don't flip. Don't flip. Don't flip. That's what he said. He said, don't flip. Then he walked up to me and he showed me a picture of a corpse with the mouth hanging open and a rat stuck in the mouth. Don't flip. Never turn against the family. Never turn against the family. You like Grizzly Adams? All right. All right. All right. I'm not going to kid you. I saw a picture of Jim Carrey with full beard but well trimmed full beard, and I was like, I'm kind of liking that. All right. Jurors see you in a few minutes. There you go. Matthew Lee. Based and awesome. They're back. Justice Mershon, please bring in the witness and the jury. Are you familiar with Robert Costello? Isn't he the guy that wrote that song Veronica? Veronica sits in her favorite chair, and she sits very quiet and still. And they call her a name that they never get right, and if they don't, then nobody else will. All right. Probably not that dude. I was introduced by Jeffrey. We were both on the advisory board of Sterling National Bank. He said Costello was close with Rudy Giuliani. What did Mr. Costello tell you about his relationship with Rudy Giuliani? He said he was very close with Rudy, and it could be a back channel communication to the president to make sure you're still good and still secure. He showed me a retainer agreement, even though I was still speaking with other lawyers. It was sketchy. Oh, that was sketchy. Oh, that was sketchy. As if your entire career isn't sketchy. I'm not. I don't want to deal with this. Is sketchy. No. Everyone knows the last thing Michael Cohen would ever get involved with is something that people might deem sketchy. Obviously, because he is beyond reproach. Are these emails with Mr. Costello? Yes, offering a back channel. Can the Trump legal team bring charges against Jackoff Smith in the Hague International Court of Justice? Would that be ironic? Only if you're using the term ironic the way that singer, the way Alanis Morissette uses it. That would make it ironic. But otherwise, I'm not seeing it. I'm not seeing it. Where she's like, yeah, so you get on a plane and it crashes. Isn't that ironic? Really do think. Where the only irony in that song is the fact that none of the examples she gives are actually ironic. Well, far be it for him to get involved with something sketchy. Please read it. All right, now I'm gonna have to pull up. I'm gonna have to pull up Adam Klasfeld. I'm gonna have to pull up Klasfeld. Good morning from New York. He approved it. In 3 words, Michael Cohen tied Trump to the system of reimbursements, and a blinking you might miss it line dropped just before trial adjourned. So obviously all 12 of the jurors got it. Adam, come on, Adam. Scrolling for the exhibits. What is that? Am I getting Lara? What happened here? Is there more? Oh, okay. So there you go. The New York Times and third-rate reporter named Maggie Haberman, known as Crooked H. Flunky, who I don't speak to and have nothing to do with, are going out of their way to destroy Michael Cohen and his relationship with me in the hope that he will flip, in quotes. They use non-existent sources and a drunk, drugged-up loser who hates Michael, a fine person with a wonderful family. I don't think he thinks he's a fine person anymore. Michael is a businessman, for his own account lawyer who I've always liked and respected. That probably has changed too. Most people will flip if the government lets them out of trouble, even if it means lying or making up stories. Sorry, I don't see Michael doing that, despite the horrible witch hunt and the dishonest media. I guess this is one of those rare instances where Trump's assessment of people was inaccurate. And isn't that statement of mine ironic? It's not really ironic. It's not irony either, if you think about it. What crime was the FBI investigating Cohen for in 2018? There was a criminal referral from Mueller's team, but what was the crime? Likely obstruction, but I don't know. It's all tragic, 100%. Yeah. All right, so there's the morning recess. We're going to get to this exhibit. After Trump's tweets, Costello, who is close to Rudy Giuliani, has sent an email to Cohen saying, "You're loved. They are in our corner. Sleep well tonight. You have friends in high places." All right, what does that mean? Why does everyone keep telling him he's loved? He's loved. This dude definitely has daddy issues. Everyone sensed his daddy issues. That's the most likely thing here. All right. Oh, here it is. Cohen said, your friends in high places sleep well. What do you think of Costello writing about his friend speaking to his client? It was I spy-ish. It was weird. I think they were dangling a pre-pardon. Okay. I would object based on that speculation. They were concerned I was going to hire another lawyer from a boutique firm. What is this? Bob Costello said to me to link to a YouTube. It was Rudy Giuliani on possibility of Cohen cooperating on Mueller probe. I wrote, why send this to me? Cohen wrote, SDNY is trying to drain you until you see them as your only salvation. These left-wing journalists want you to fail. If you want more from your former boss, you should make that known. What was this? Pressure campaign. That's a pressure campaign? They're saying if you need legal help, that's a pressure campaign? What the hell does that even mean? How is that a pressure campaign? And Cohen said, I hired other lawyers. I spoke to my family what to do. They said, why are you hanging on to that loyalty? We're supposed to come first. Oh, gosh. Boo-hoo. Oh, my family. Oh, my family. What could I do? My family said I'm hanging on too long. I hired other lawyers. I spoke to my family what to do. They said, why are you hanging on? All right. What did you decide? That my loyalty should be my family and to my country. I'm standing up for my country against the horrible orange man. I'm standing up for my country. Did you plead guilty to excessive campaign contribution to Stormy Daniels? Yes. To influence, objection. Sidebar. The objection is sustained. Why did you pay Stormy Daniels? For Mr. Trump's campaign. So he paid him. That's what he's saying. And you pled to a role in FEC illegal corporate contribution? Yes, for AMI to Karen McDougal. The FECA violation is only in to assess Mr. Cohen's credibility and to provide context. FEC violation. Did you plead guilty to tax evasion, false statement to a financial institution? Yes, those were unrelated to Mr. Trump. Because he's a professional slime ball. Most crooked guy on earth. After you pled guilty, the President Trump shows tweet about don't retain Michael Cohen, contrasting him to Manafort. What effect did this have on you? Angst and anxiety. Let's see this tweet. Let's see the tweet here if Adam has the tweet. Trump wrote, I felt very badly for Paul Manafort and his wonderful family. Justice took a 12-year-old tax case, among other things, applied tremendous pressure on him. Unlike Mike Cohen, he refused to make up stories in order to get a deal. Such respect for a brave man. So that made him feel angst and anxiety. Okay. Yeah, very much so, obviously. Did you then plead guilty to false statements to Congress about Trump Tower Moscow? Yes. Did December 12, 2018, were you sentenced? Yes, I was sentenced to 36 months, restitution, and 2 fines. I surrendered May 6, 2019. Did you testify to Congress before surrender? Yes. Representative Elijah Cummings reached out to me through Lanny Davis. Were you on TV? Yeah, I apologize to the country for existing. Felix says Jacko Smith is a habitual line crosser with all the evidence tampering. He gave all this evidence to other habitual line crossers. They are all so scummy. They're so scummy. So scummy. Lou Valentino played a videotape of Cohen praising Trump. He flipped bad. Yep. He did flip bad. That's true. I guess maybe you can't blame that one on Trump. And the truth is he probably was encouraging him to stay on the right side when he was praising him initially. Michael Jewish Fredo Cohen, who took a check. Yep. Yep. All right. Did you provide testimony to the Office of Special Counsel? Yes, I admitted that my previous testimony in Congress was false. How much time did you serve and where? 13 months in Otisville, then home confinement. Otisville? Otisville? I'm sorry, Mr. Luthor. Otisville? If you're old enough, you get it. And if you're not, that was for boom, Gen X people. No, not Gen X. Gen X might be too young. That's for baby boomers. Otisville! I'm sorry, Mr. Luthor. I'm sorry. I'm curious. I'm trying to see if anyone got Otisville. Was it Otisburg? Was it really Otisburg? You should be sorry. Why are you not 85? Was it Otisburg? Nice. Nice. Kim P. The best Superman ever. When I met Dean Cain, I told him he was the best ever. But I was fluffing. Christopher Reeves was like classic Superman. That's what everyone thought Superman looked like, based on the original comics. Christopher Reeve. You're right, it was Otisburg. Otisburg? Did you provide testimony to the Office of Special Counsel? Yes, I made my previous testimony. Oh, we got that. Were you briefly sent back to prison? Objection, overruled. I was head up to the Bronx to GEO, but I received a call from Adam at 500 Pearl Street. That's a courthouse, 500 Pearl Street. That's where the federal courthouse building is. I'm told I need to go there. I asked Jeffrey K. Levine to come. They showed me an agreement that violated the First Amendment. Objection. I don't know. I have no idea what he's describing here. But obviously it's something that Trump doesn't want him to be able to speak about. I'll ask a few leading questions. Did the agreement constrain your ability to speak? Yes, I was writing a book. In March 2023, did you testify to the grand jury and did you have immunity? Yes, and that is my understanding from my lawyer. Have you asked us to help get your federal sentence reduced? Yes. Was your understanding that the SDNY prosecutors declined to receive such a letter to reduce? Yes. But our offer, has it influenced your testimony? No, 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 no. No way at all. I would never, ever lie. Oh, no. Why would anyone think that I would lie? That is the most absurd, outrageous, completely defamatory statement in the world for anyone to think I ever would tell a lie. What did you do with your old phones? One in a box. I don't know what that means. Another in a pouch. Oh, there you go. I was FOIAing the BOP and I wanted to record the conversation, so I powered up the older cell phone. The BOP. The BOP. Were you under any legal restriction on how to use the phones? No. Did you give us the phones in January 2023? Yes. I not altered my previous recording with Mr. Trump. Of course not. Very reliable. Very, very reliable. Have you made public statements that you should not have been prosecuted on tax and bank statement charges? Do you dispute the fact? Objection, overruled. They said they would charge my wife on the taxes since she'd signed them and the HELOC. I dispute that it was material. But you accepted responsibility. Oh, totally. Yes, I did. In fact, I'm still under supervised release. Did you testify in the NYAG's Trump org case? New York Attorney General's Trump org case? Yes. And when you cross-examined about statements, oh, I see, Mr. Blanche is rising. Do you want to approach? Sidebar then. The objection is withdrawn. Did you admit to lying to Southern District of New York Judge Pauley during your plea? I did, because I'm always lying. I cannot spend 3 minutes without telling a lie, as you obviously can tell while I've been sitting here on the stand for the last 9 hours. But you didn't lie to Judge Pauly about campaign finance. Oh, no, ma'am. Oh, no, ma'am. Oh, no, ma'am. No, sirree, ma'am. Oh, no, ma'am. I would not. Oh, no, ma'am. No, ma'am. No, 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 ma'am. No, ma'am. Are you a lawyer? No, I was disbarred. And as a felon, I can't own New York City taxi medallions. So now I make a career out of bashing Donald Trump. Do you have real estate? Only one secondary apartment other than my residence. What do you do? Media and entertainment. I have a career bashing Trump. Media and entertainment. Entertainment as in constantly full of hot garbage. What do you do? Podcast I call Mea Culpa. My initials. Yeah. Another podcast with Midas. I wrote Disloyal because that is the story of my life. Because I'm slime. What about the book Revenge? It's about the Southern District of New York's corrupt prosecution against me, the weaponization of DOJ. In February 2021, did you invite Stormy Daniels onto your Mea Culpa podcast? Yes. Have you continued to be the recipient of negative posts by Mr. Trump? I was. Now they show the horse-faced Truth Social post again. Let's see what we got from Adam on that. Oh, so that's why they don't want to talk about it. So they said that his prosecution was retaliatory. That's where they were worried he was going to go, to basically try and make Trump look vindictive, and that would be something that would be a character assassination. You can't do a criminal defendant. Trying to find his. Mike Conan's podcast. I need to mea culpa for two reasons. First, it's my responsibility, which I take totally. Second is because they're my initials. Full disclosure, I'm somewhat embarrassed to say I never made this second connection. You shouldn't be embarrassed. No one else got it either. No one else. No one. Nobody got that. So we don't get the horse-faced True Social post. Do you have that? Do you have that here? No. Did Mr. Trump sue you? For $500 million, he dismissed it. Did you have any regrets about your past work with Donald Trump? Yes, I did things for him I should not have. Bullying people, they were good times. I lost my moral compass. We'll break. Let's see his final words in the name of, as Adam Caswell says it. He says the closing lines were, I regret doing things that I shouldn't, for Trump, that I should not have. Lying, bullying people in order to effectuate a goal. I don't regret working with the Trump organization. As I expressed before, I had some very interesting, great times, but to keep a loyalty and do the things that he asked me to do, I violated my moral compass and I suffered the penalty, as has my family. No further questions. All right. Now we finally get here. This is what the whole trial has been waiting for. The cross-examination of admitted perjurer Michael Cohen. Let's see how it goes. Make sure I covered everything. Anything new pop in here? Oh, we're going to Addis Ababa, Mr. Luthor? It's Mr. Luthor. Yo, Mr. Luthor. Those of you who don't know, Otis was Lex Luthor. When Gene Hackman played Lex Luthor in the original Superman in the 70s, Otis played his bumbling henchman. And when Lex Luthor created a map of what he envisioned the United States to look like after he owned it. He was looking at it and he was remarking about how we have Lutherville, Lextown, Otisburg, Otisburg. And he starts freaking out at his henchman. I'm sorry, Mr. Luthor. It's a small area. Otisburg. Good clip. All right. Here we go. They're back. Todd Blanche, Julian Cross. Mr. Blanche. We've never met, but you know who I am, don't you? Yes. You call me a little crap on TikTok. Nice. You never met me. But you call me a little crap. Sounds like something I would say. Approach. I like the opening. I like this. Let's see how Adam covers this. Blanche asks Cohen whether he recently described as a crying little crap. Cohen starts to say, it sounds something I would say before prosecutors object. Sustained. Why is this? Trump's lawyer Blanche, you commented about jury selection. Objection sustained. You said on TikTok that Mr. Pecker corroborated you. Someone called me and told me. You've been following it on CNN and MSNBC, right? I watch, for example, about protests about Israel, so I see it. Because if you're a witness, you're not supposed to be following the trial. You call President Trump a dictator douchebag. Sounds like I'd say that. Lanny Davis, your lawyer, do you recall him saying line prosecutors to report on the top? Objection sustained. Do you remember the prosecutors being frustrated you leaked to the press? No. Take a look at this email. Now? From this document, yes. Oh, see, he just lied. He already lied. You going to show us the email, Adam? Let's get the analysis. The start of Cohen's cross highlights the pitfalls of a witness mouthing off on social media and broadcast days before taking the stand. Cohen agrees the DA's office urged him repeatedly to stop talking about the case. You see, like, this is... He's trying so hard. He's trying so hard, Adam. Cohen agrees with Blanche that he also said Trump belongs in an effing cage like an animal. That's an important quote, because now he's trying to put him in the cage. What happened? Oh, no. There we go. All right. Lanny Davis, your lawyer, do you recall him saying line prosecutors to report on top? Objection. Okay. Do you have the email? You don't have the email. All the other stuff you got, not this one. That's annoying. From that document, yes. In February 2021, you were going on TV talking about the investigation. I go on TV often, so I don't remember. You promised your attorney you'd stop TV. Objection sustained. Blanche says, look at this email. It disappeared. It disappeared from my screen. Your lawyer told me a member of the DA's office. Sustained. You continue to talk to the press about this case, right? Sounds correct. I don't want it to sound correct. Is it correct? It is. February 23rd. See, even that, he's showing like what it, the way he's answering is like a douchebag. This is good. It's important for the jury to recognize him for the douchebag slimeball he is. February 23rd, the DA's office, you gave him 2 phones. Jeremy Rosenberg, yes. Do you remember telling Don Lemon, 9-time award winner of Worst Journalist of the Year, Don Lemon, about giving your phones to DA, then saying they already had the info. I don't recall either way. Look at this. Cohen puts on his reading glasses. I don't recall. 6 days after the grand jury, once again, the DA's office was frustrated. You're continuing to talk on TV, right? I don't recall. Because you are a blabbermouth. A blabbermouth. That's really for the boomers. All right. That was really for the boomers. I think like no one younger than my sister will remember that one. He testified in detail about calls with President Trump in 2016, but now you can't remember things from 2023. Is that your testimony? Not these conversations with Lanny Davis. How about last March? They told you to stop TV. You don't remember the DA's office telling you you were unwittingly helping President Trump by going on TV? I don't remember. You were called down to DA's office as a possible rebuttal of Costello's testimony. I've spoken with them. They tell me probably better off if you don't speak of it. But I have a First Amendment right to speak, and I get paid a lot of money for it. I get paid a lot of money for this. How do you think I make a living? How do you think I put bread on the table? I ain't got no taxi medallions anymore. I got my law license. I was disbarred. How the hell am I supposed to make money other than trashing and lying about Trump every time I can? How often have they said it? I don't recall. Fewer than 5 times. And you haven't done it. You do 4 podcasts a week. Yes, hundreds since the case has been charged. I haven't done the math. We can do it. Hundreds. Nice. I'm loving the tone here. I'm loving the tone from Blanche. He's coming in here, and he has Michael Cohen there, basically tied to the chair, and he's just wham, 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 wham. Oh, uppercut. Oh man. Oh no. This is good. I'm enjoying it. We can. Hundreds. You're active on X? Yes. Yeah, okay. I'll tell you right now. I'm totally doing a players on this. I am totally doing a players on this. Someone already asked me to take Todd Blanche. I'll tell you right now, I really want to take Todd Blanche. This sounds like such a fun read. Oh my God. This sounds like I am totally doing a live action of this. Totally. Then I think to myself, I got the New Jersey accent like really nailed down pretty good. Oh. Definitely doing a live read though. All right. If you'd like to join in for a live read, like participate, because I definitely see here, anytime I'm having a live read a court thing, you need 4 people. You got the witness, you got the judge, and you got 2 attorneys. So you really need 4 people, which means it's me and 3 people. I really think I should mix it up. As to who I bring in. Our players the first time around were magnificent. Every one of them. Spectacular. Really excellent. If you missed the players show that we had, you don't know what you're missing. It was really good. It was really, really good. I really think I'm going to do a live read of this transcript on Saturday night. Definitely thinking about that. Definitely like this is fun. All right. Nightly TikTok? Yes, I can't sleep. What a loser. And nightly TikTok? Yeah, I can't sleep. One of the reasons you do TikTok is to make money, right? Money's made. You speak about Mr. Trump every day. I do it 6 days a week. 6 days a week. So it's not every day. I take a day off. On your beatdown cast, March 19th, you displayed a binder. You've regularly commented that you want President Trump in jail. Yeah, I would like to see that, sure. You sell a t-shirt depicting President Trump in an orange jumpsuit behind bars. Yes, sir, I do. It's only $49.99 for the t-shirt. You can buy one yourself if you want. That's one item. We offer this into evidence a $32 $32 t-shirt with President Trump in jail. Yes. And the coffee cups, send them to the big house, not the White House. So it's not just this t-shirt. Sustained. How is that sustained? What's sustained? What's sustained? What's the objection? I don't even know what's the objection. Obviously, you changed your view of President Trump in August 2018. When I spoke on George Stephanopoulos, you still believe in a building with Trump's name on it? Yes. You rent out an apartment you own in Trump building for $15,000 a month? He's broke. He's totally broke. Totally broke. Dude is spending $170,000 a month on renting an apartment. $180,000 a year on renting an apartment. Totally broke. Oh, boo-hoo. Boo-hoo. Oh, it must be so hard living his kind of life. What a rough life it is for Michael Cohen. His family suffered. It's been so hard on him.
Oh, poor you.
So tough being Michael Cohen. It was so tough. So hard. Miss Tessmacher! Cohen never had moral compass, still does not say that's true. Did you hear Representative Dan Goldman prep Cohen for cross? I'm sure the two of them hit it off like peas and carrots. Ever since that day, Michael Cohen and Dan Goldman got on like peas and carrots. Mama always says, stupid is as stupid does. Ever since that day, Michael Cohen and Dan Goldman. This is way too much fun. My job is way more fun than any person should have. You made millions in taxi medallions. I did. President Trump was happy with your results. He was. You helped present the Trump children to the media. I did. You read The Art of the Deal twice. Yes, an excellent book. It's a masterpiece. You saw yourself in President Trump? Yes. The guy I'm calling a slime ball who should go to jail. You can see how mad he is that he went to jail. And he wasn't pardoned. You were obsessed with President Trump. I was in a cult of Donald Trump. I was hoodwinked into joining a cult of Donald Trump. That's not my fault. I fell in with the wrong crowd.
Oh, poor you.
What you said in 2015, it was the truth. It was how I felt. In 2016, you spoke in Cleveland with President Trump, a church. Trump's lawyer says you spoke to Vanity Fair and said you were the one who protected the president, stopped leaks, would take a bullet for him. Yeah. You said you were offered $10 million to write a tell-all, but you wouldn't. I would not. During the investigation, he was offered $10 million. Totally. Oh, was it true that you were offered $10 million? You're under oath. Were you really offered $10 million? Really? Who offered it to you? Name the person. During the investigation, he's so full of crap. This guy is such horse manure. During the investigation, you said you didn't see the Trump children. Not that I couldn't. You lied in February 2017 to Congress, then got raided. Did you say, boss, I miss you so much? Don't recall. I miss you so much. It's so horrible. It's horrible without you, Donald. You don't write me anymore. You don't call. There's nothing. I can't talk to you anymore. It's so awful. Why doesn't Donnie return my calls? I guess he's afraid I've turned informant and maybe I'm going to rat him out. Oh, I'm going to sit here and he thinks I might lie. You remember when you decided to cooperate? I don't. At the first meeting, you gave a reason why you were going to meet with them. You said your life was turned upside down in the Steele dossier and you'd never been to Prague. What? You know why I'm turning on him? Because I'd never been to Prague. Why the heck wasn't I in Prague? I always wanted to go to Prague. What you testified, it was a lie. It was not accurate, but it was a lie. I wouldn't call it that. So when you didn't testify truthfully, how many things did you lie about? I don't know. You told him you were hurt. You heard of the Access Hollywood tape. You were in London at the restaurant Lulu's, right? Yeah. But then you told him you didn't speak with the president, right? It says I might have. Don't read. So in 2018, 2 years after Access Hollywood, you said you didn't know if you spoke with President Trump. But yesterday, 8 years out, you said you have a specific memory of President Trump being there. You pled guilty twice, then spoke to Congress in February 2019, testifying completely differently than what you said before, right? Yeah. You were supposed to surrender in March 2018, but got delayed to May and testified. Did Anthony Scaramucci visit you in the big house in Otisville? Yes. Let's take a break because he's getting butchered here. Your Honor, we're going to take a brief recess while our star witness here recovers from all those body blows that Todd Blanche has been landing on him. So if we could just get an extended recess here for a few days so he can recover, maybe get some stitches, we'd be appreciative of that. He does act like a jilted girlfriend. He's so sad. So sad. Ah, God. Sincerely, stop referring to that man as the slimiest man on earth. Justice Somerville will do her homework on you. My own lawyer went through school with her and has presented 3 times before SCOTUS. She considers such statements publicly made to be extremely unprofessional. This behavior will harm you if you continue. All right. They're back. Justice Merchan. And I'm sorry, Texas TX47. I am not going to sugarcoat just what a terrible human being I think this man to be. There you go. I'm not going to sugarcoat it. I'm coming in here right now, and I am sharing with you my perspectives as to how this testimony went down. So, this is not a law show. This is not like, oh, I'm going to sit here and I'm going to calmly give you a breakdown as to what the reading is over here. That's not what I'm doing. And if that somehow means that I don't have a legal right to uncover information, I don't know what to tell you. I know what to tell you. Yeah. So, Justice Merchan says, jurors, we don't meet this Friday either. And Thursday will only go to 4 p.m. Okay. Mr. Blanche, you've been in Otisville 3 months and you asked District Attorney New York prosecutors why you should meet with them. I asked. Look at these notes. You asked the line, why are you here? 2 lines above. From December to August. Under Rule 35, your sentence can be amended if there's cooperation in a year. Judge Pauly had that in his order. Your lawyer asked the Attorney New York if they would help write a Rule 35 motion. You were there? I believe so. And they didn't commit. Then in December, Roger Adler filed a Rule 35 motion. Yes, based on cooperation. So, let's see what that is. What are we talking about? So under Rule 35, the government believes that a sentenced defendant has provided substantial assistance in investigating or prosecuting another person and may move the court to reduce the original sentence. Ordinarily, the motion must be filed within 1 year of sentencing. There you go. There you go. So lots of reasons for him to be all excited to try and testify against Trump. The federal judge denied your motion, right? He did. But after you got out due to COVID, you tried again. With disloyal and mea culpa, you called Trump a boorish cartoon misogynist. Sounds like something I would say. You called President Trump a Cheetos-dusted cartoon villain. Yeah. You said, I effing want to see him locked up. Sounds like my language on mea culpa. Yeah, he's obviously taking a lot of accountability. That's why he calls it mea culpa, because I'm taking accountability. That's why I'm taking accountability when I'm going after the Cheetos-dusted cartoon villain. He really sounds like a jilted boyfriend. I want you to listen to it, not the jury. Headphones on. Your Honor, may we approach for a moment? Yes. You said President Trump should be in handcuffs and you made money off of it. I did. Ooh, financial incentives for him to lie and get him in handcuffs. You're motivated by a desire for fame. No, not at all. Why would anyone even think such a thing? That sounds crazy. You made $2 million from disloyal. Yes. In January 2021, you thanked the DA's team for continuing their case, right? I did. He thanked them for prosecuting Trump. Thank you for prosecuting Trump. You started meeting with Mark Pomerantz? Yes, by Zoom. Sidebar. You wanted the DA's office to say you were helping, right? I would say so. Until November 2021, you were still under home confinement. I was allowed to go out 3 hours a day in Manhattan with an ankle bracelet, then a phone. You were doing your mea culpa podcast from your house and going on TV, like in January 2021 on MSNBC's Ali Velshi and Joy Reid. I've appeared on their shows frequently. Have you met D.A. Bragg? No. How much did you make from your book, Revenge? $400,000. You call yourself a fixer. Yes. Are you fixing things that you broke? No. I'm not the one who broke everything. Judge Merchan says this might be a good place to stop. Well, there we go. But wait, there's more. Mr. Blanche, can you finish your cross-examination on this witness by the end of Thursday? Our expert witness would like to know, Trump's lawyer Blanche says, yes, our expert witness would like to know about the charge. Oh, so this is a mistake that he shared out here, I think. I don't think he meant to do that. I think that's the end of it. Should we check out Adam? Let's see what Adam's take is on all this. See, this is... Blanche keeps rattling off Cohen's media appearances, which allegedly frustrated the DA's office. Cohen coolly says he does not recall their frustration about an appearance with Don Lemon. During all this, Trump's eyes appear to be closed and his head appears to be tilted up. Cohen says he doesn't recall leaking, whether he leaked the fact that he gave his phones to the DA. Well, there you go. Yeah. Okay. So I just feel like there's too much flavoring added by Adam. I don't think it's intentional. I think he really looks at himself as a journalist. I think he really tries his best. I think he really tries his best. Did I? Did I? Did I really? Is it more TX47 yelling at me? Oh, I missed you saying, don't be looking like the squirrels. We are not supposed to mutilate, skin the cat. I think I missed. Oh my, I really did. Endug saying, Cohen's TikTok videos, Joe. Pelosi calls it tic-tac-toe. Really? Oh, so that okay. Now I understand what you're saying, Endug. You're saying to me, I apologize that I missed your stuff. That what she calls tic-tac-toe, that you just want me to look through his TikTok videos. Let me see if I can find his TikTok videos. Before I let you all on out of here.
Excuse me, sir. Would you take the food or would you take an ice?
Is it meaculpa.co? No, it's a clothing brand. Let's see if we can find my Cohen. There he is. There he is. Let's see what we got here.
10 o'clock again. Same bad time, same bad channel. See you then. 10 o'clock again.
Yeah.
Michael Cohen here with another Michael Cohen Reacts. Well, it's been a while because, you know, for a week I've been suspended on TikTok, but I'm back and I will be on for my 10 o'clock p.m. show tonight and every night until, of course, TikTok suspends me again. But who cares? Judge Merchan just ruled that the trial will start on April 15th. All right.
Let's find something else.
Michael Cohen is a convicted liar, and he's got no credibility whatsoever. He was a lawyer, and you rely on your lawyers.
I'm not even sure what that. Is that his? Did he upload that? Why would he upload that? Is there a particular one you want me? You want me to pull up here?
Because Tucker Carlson is the most important normative force in the Republican media world.
All right.
He is to the Republicans now what Rush Limbaugh was before he died. He is the most important voice at Fox when it comes to the far right. He essentially runs an independent operation inside Fox.
I can't stand Rick Wilson.
Mr. Chairman,
Yeah.
you have repeatedly said that this committee is all about protecting the First Amendment. And what's unfortunate here is that we are talking about Twitter and that we are not.
I don't know. I want something that's going to make me laugh at it. And what the heck? What are we looking at? What is this? I don't know what I don't know what I'm looking at here. And Doug. And Doug. Wow. Wow, isn't that hilarious? Isn't that amazingly funny?
Here than in New York. It's great. And don't worry, Michael, we're not going to shut you down. We're not shutting you down on TikTok. We're giving you a platform. We think you're doing very strongly, but don't worry about it. I'm going to go to jail and it's going to be okay.
This
And
is
I'm
a
going to
great
do it
Trump
in your
impersonation.
honor, quite frankly.
This is a great Trump.
Z-Pack, fantastic.
But Michael, please tell them that I'm really a nice person. Please tell them that I'm not that bad. There's a lot of people saying I'm so bad.
You know, it's funny that you bring that up, Z-Pack, because something that I said when I was
He really does look like Data. I never noticed it before. He really looks like Brent Spiner.
testifying before the House Oversight Committee,
When you mean when you were lying to the House Oversight Committee.
I turned around and I said that Donald Trump has shown acts of generosity, but he is not a generous person. He has shown acts in front of me of kindness, but he is not a kind person.
He's a terrible human being. Terrible, terrible human being.
You know, and those words actually were brought up the other day by, I think it was maybe Joy Reid who said it, or Alicia Menendez. It was somebody. They said it to me that they had brought up. They asked me to explain it. You know, there are people who can be generous, but they're not generous people, if that makes any sense. And sadly, Z-Pack,
No? I don't know what that means.
That's you.
That's so rude. You're such a nasty person. I thought you would turn over a.
All right. Well, I gave it a few shots. I might have had just bad luck here, but his tic-tac-toe. Maybe we'll find other stuff from his tic-tac-toe. What do you have for me, N. Doug? His account is constant unhinged rants about Trump. Oh, yeah. Yeah. I mean, if you turn on his show, I have no doubt. Anyway, all right. So I'm gonna be landing my plane over here. It's time for us to call this one a night. I'm actually supposed to be sending out an email and joining in on stuff here, so I need to take care of that. I thank you all for joining me tomorrow. I do expect to be doing a locals. That's at goodlogic.locals.com. Goodlogic.locals.com. Also, I will be back here tomorrow evening at 10 o'clock, God willing. Until then, my friends, I thank you so much for joining me. I expect to see you all here tomorrow. Make sure you hit like, subscribe, share, do all that good stuff. Do not eat the bugs. No matter what you do, no matter what happens, don't eat the bugs. And as always, I say good night. Myopic adult with a TikTok platform for others just like him. Oh, yeah, no doubt. Yeah. Good night. Godspeed.